I'm going to start off by giving a brief overview of various domestic and international practice developments. So significantly, this year we celebrated 10 years of the America Invents Act, September 16th, 2011. It was voted into law, kind of bringing in a change in US patent law jurisprudence, migrating to a first inventor to file system regime, as well as introducing various new opportunities for post-grant review. We're also, just a couple of recent statistics in view of the pandemic, perhaps, year over year, we learned that the number of patents granted in the US fell by 7.5% compared to 2020, and the number of new applications initiated at the US Patent Office dropped by 1%. You may have also heard that we're in the process of bringing on a new director of the U.S. Patent and Trademark Office. Kathy Vidal has been nominated and recently approved by the Senate Judiciary Committee. She's generally widely approved by members of the patent bar, having an engineering background by training and also currently in private practice. Wanted to touch on, looking at initiatives at the agency level, a lot of investments recently in terms of infrastructure. So we're all getting ready for the adoption of Patent Center, which is an initiative that the Patent Office has put forth, a streamlined online resource and portal, bringing together a lot of currently disparate features in a much more user-friendly online environment. There was also a recent announcement, some of you may have heard about the DocX initiative. The Patent Office was going to impose a surcharge for non-DocX filings as of January 1st this year, and has decided to push that out until at least next year. But it's going to be an opportunity to really improve the data quality, providing a smarter interface so that information such as metadata can be analyzed in filings and potentially stripped out. So in general, the Patent Office is looking at electronic submissions in general to figure out how to enhance data quality, everything from a normal application to looking at sequence listings and large tables. Lastly, I wanted to point out that there was a recent announcement by the USPTO that they're probably going to transition to registering patent and trademark certificates electronically only rather than in paper. There's already a number of other jurisdictions that have gone that route. One thought in terms of patent issuance is that the timing between allowance and issuance will probably be tightened up quite a bit. So that's something to pay attention to as well going forward. I wanted to touch briefly on the topic of patentable subject matter, as that's still quite a hot topic in terms of patent prosecution. There has not been any recent further guidance on patentable subject matter. However, there was a study commissioned by the Patent Office over the past year at the request of several senators to look at the state of jurisprudence and how it has impacted investment and innovation, particularly in critical technology sectors such as quantum computing and AI, precision medicine, diagnostics, and pharma, with feedback from the public due back in September of 2021. And so that'll be evaluated, and probably, we'll see some interesting data analysis there. Also, I'm going to be on the next slide talking about a related pilot program pertaining to patentable subject matter, and just a point of public interest related to artificial intelligence. An Australian federal court over the past year said that AI itself can be named as an inventor, so kind of distinguishing Australian jurisprudence in that regard. As a jurisdiction coming out in favor of AI actually being able to be named as an inventor. But just a few points of agency clarification and guidance. The Patent Office probably back in 2020, put out an update regarding patent term adjustment in view of the Supernus decision. We are still seeing issues with the way that the Patent Office is calculating PTA as it relates to certain applicant delay instances. And so I just wanted to mention that as something that we're still paying close attention to make sure that no requests for reconsideration should be filed. The Patent Office came out to remind applicants explicitly that patent applications must properly present examples in a manner that makes it clear to distinguish between prophetic examples that are describing predicted experimental results and actual working examples reporting actual experimental results. So that was something that the Patent Office felt strongly needed to notify applicants as they prepare new applications. And lastly, Eric is going to be talking about the Arthrex decision, providing that the director has authority to review a PTAB final decision in an inter partes review via rehearing. And so the Patent Office spoke specifically on that point and has been updating an Arthrex Q&A section on their website. I also wanted to just quickly, I try every year with this presentation to revisit the pilot program activity available at our disposal before the Patent Office. So I'm just going to jump through this list very quickly. We have prioritized examination based on COVID-19 related patent applications, a petition to make special with no fee associated with it. The Patent Office recently extended that to March 31st of this year. We have track one prioritized examination. Again, applicants, large entity, pay $4,200 to request prioritized examination, special handling with a goal of reaching a final disposition within about 12 months. The Patent Office, as they kind of gain comfort with how they're able to accommodate and handle those requests, have upped it now to 15,000 allowed requests for the fiscal year. So that is definitely available to us as well. After final consideration pilot program, allowing a little bit more time for examiners to handle submissions after final, has been extended through September 30th. The fast track appeals pilot program, which is only a year or two old at this point, was recently extended through July 2nd of this year. Just a reminder there for the appeals were getting quite behind at the PTAB. And for a fee of $420, there would be a goal of 6 months to a final disposition on your pending appeal. This is a new pilot program extended to September 16th, 2020, the PTAB motion to amend pilot program, providing patent owners with two options not previously available, either to choose to receive preliminary guidance from the board on its motion to amend, or the opportunity to file a revised motion after receiving the petitioner's opposition to a motion or receiving PTAB's preliminary guidance. So for matters before the PTAB, that's definitely a pilot program that can be taken advantage of as we navigate these post-grant proceedings. Just announced a deferred subject matter eligibility response pilot program, which I hinted at on the previous slide. This is going to be a by invitation program starting February 1st and at least running through July 30th of this year. It's going to be an opportunity, again, by invitation to applicants to defer the question of subject matter eligibility, the 101 issues, until all the other issues in the application, substantive in terms of obviousness, novelty, written description, are properly addressed between the examiner and the applicant. So sort of an interest, we're going to be waiting anxiously for these invitations, especially interesting considering how there's a lot of discussion about the conflation of 101 issues with 102 and 103. So that'll be something to look out for. The IP5, these international PPH and collaboration in terms of search and examination is ongoing. And lastly, just a reminder, we spoke about this last year, but at the beginning of 21, the sunset of the first action interview pilot program. So unfortunately, that program intended to kind of facilitate early interaction with examiners is not an available mechanism any longer. Okay, I just wanted to touch on some policy initiatives before the Patent Office, kind of looking back over the past year. The administration came out in support of waiving international patent protections on vaccines in view of COVID-19. In June, we saw a large $250 billion bill, the Innovation and Competition Act, to bolster scientific innovation and improve the positioning of the US in terms of international competition. In July, there was an executive order promoting competition in the American economy. There was some discussion around the handling of non-compete agreements and whether at the federal level, the FTC was going to evaluate those agreements and the impact that they might have in terms of limiting workers' ability to change jobs. And we've seen a lot of activity at the state level as well around non-compete agreements. Very recently, I think earlier this year, in terms of standards essential patents, the government revisiting a 2019 policy statement that the Department of Justice had published, looking at standard essential patents and indicating that the public interest could perhaps be harmed by owners seeking injunctions. And so that there's some discourse right now around whether injunctive relief might be limited as a result in the context of standard essential patents, and how is that going to impact and maybe provide leverage to potential infringers of such patents. So a lot of activity there as well. And then diversity continues to be an initiative. The Patent Office recently updated its patent bar eligibility guidance, and I think just earlier this week announced the creation of several new programs it's hoping will improve access to patents and trademarks for those historically underrepresented in the IP system. A couple of other things, the PTAB of interest to the life sciences and pharma communities. The PTAB updated an analysis of all AIA petitions challenging Orange Book patents and biologic patents through current as of June 2021. And there's a lot of information in this patent study regarding the number of petitions filed, institution rates, and claim outcomes based on final written decisions. So that's a resource that's available. We're going to hear from Nate regarding trademarks as a other bucket of IP rights, but I just wanted to touch briefly on copyrights. We're seeing anti-piracy measures, looking to identify how to better protect copyrighted works online. That's a very hot topic right now. And then there's also been the establishment of a copyright small claims board, which is going to be available hopefully come this spring as a mechanism for dispute resolution, smaller disputes, maybe under $30,000 or something along those lines. So there's been proposed rules for how to initiate these CCB proceedings, and there's going to be more coming out on that. All right, just wanted to move to some international practice developments. Europe specifically, we had two big things going on over the past year. The first, of course, Brexit at the beginning of 2021, the UK leaving the EU effective January 1st, 2021. Again, there was no impact on patents as the UK remained part of the European Patent Convention. But on the trademark and design side, we had a September 30th deadline by which to kind of duplicate pending applications over to have concurrent filings in the UK. And then certainly for new filings since then and to date, the need to separately pursue protection in the UK with respect to trademarks and design. So we're currently living in that new regime. And then a lot of people are starting to hear about the Unified Patent Court concurrently with the Unitary patent. This was sort of a sleeper for quite a while. We had gotten quite geared up for this a few years ago, and they weren't able to get the number of ratifications required to move it forward. But within the past couple of weeks, we saw that Austria ratified the UPC, just behind, I think, Germany and Slovenia. So things are going to move forward now. And we're going to get ready for the launch of the Unified Patent Court and the issuance of unitary patents. And happy to speak more about this as we learn more from our associates and kind of revisiting the topic. But opposed to independent validations in different member countries, we're going to have the opportunity to obtain a unitary patent for those EU countries that are ratifying the relevant agreements, and it's going to be governed and enforceable before the Unified Patent Court that's going to be established. So there's a lot of competing factors and decisions to be made. European patents that are already in force, there's going to be an opt-out period, and then going forward, if you choose to get a unitary patent, then that'll be before the Unified Patent Court in terms of enforceability. But a lot of good things on both sides of the equation in terms of streamlined annuities and translation costs. I think we were at the time, it was, if you were an applicant that validated in at least maybe 4 jurisdictions, it could very well make sense to go and proceed with the unitary patent as opposed to the individual validations. But, along with this central enforcement also comes the possibility or threat of central revocation, and kind of dealing with a new jurisdiction with a lack of precedent and familiarity with, procedure and whatnot. So it's going to be very interesting to see, how that unfolds. And I think we're definitely going to be, working with this new system within the next year. And lastly, I thought, before I turn it over, just touch on a few other jurisdictions, things that we've been following. In China, a lot of new rules went into effect as of June, harmonization with a lot of the other patent systems and expanded rights, patent linkage, creating a new form of pharma patent litigation for the marketing approval process of generic drugs. Also the availability of, equivalents to our patent term adjustment and patent term extension. So we're learning more about that as China continues to build its IP policies. Canada, very interesting. We're already dealing with new requirements around requesting extensions of time. Now, the Canadian Patent Office requiring an explanation of good faith as to why extensions of time are required. And we've learned that within the next perhaps 6 months or so, claim fees are going to be due, whether at the time of requesting examination or at the time of allowance, which will be new. In Brazil, there was a very interesting and kind of confusing development with respect to a constitutional challenge of the patent term provisions in place. The court there deeming the current set of laws to be unconstitutional, which cast a lot of confusion around the term of a number of already issued patents and exceptions to navigate, et cetera. So we've been hearing from our associates there quite a bit. And lastly, in India, this was the first year with new requirements around the annual working reports. And just to note that they did establish a new tribunal specialized in IP matters, joining the likes of the UK, Japan, Malaysia, China, also now featuring specialized IP courts. So that is an overview of domestic and international practice developments. I'm happy to answer questions later, but for now, I'll give it back to Amanda.
Thank you, Nicole, for those updates on domestic and international practice trends. As a reminder, if you have any questions for Nicole, please send them to me in the chat and we'll try to get to them at the end of the presentations. You can find Nicole's contact information on our website, lalaw.com, or by scanning the QR code on the screen. Our next presenter is Nate, who will talk to us about trademark and copyright decisions.
Yeah, there were a number of interesting trademark decisions this year. We'll jump right into those, and then we'll turn to some changes in the trademark rules of practice. And then finally, we'll take a look at an important copyright decision that came down. So, first up is Snatters versus Frito-Lay. This case deals with whether the generic name of a class of goods can become a trademark after years of extensive marketing and commercial success. This is a culmination of a dispute that went on for about 12 years. These plaintiffs, Snyder and Lance, had applied to register the trademark pretzel crisps for these crispy pretzels back in 2010. Frito-Lay had opposed successfully this application on the ground of genericness at the Trademark Trial and Appeal Board, the TTAB. So this case has been up and down on appeal several times, including this appeal to the district court, where the rules allow the parties to rely on the old evidence from the lower board proceeding, as well as introduce new evidence on the appeal. So as kind of a threshold matter, the court looked at the standard of review for evidence and factual findings. So any new evidence introduced during the appeal, of course, would be reviewed de novo. But there was a question about whether the evidence from the board proceeding below should also be reviewed de novo, or whether it's entitled to deference as administrative agency findings often are. So the court here observed that all the evidence and the findings they'd have to be reviewed all together anyway, old and new evidence side by side. So they decided it should all just be reviewed de novo. So turning to the substance of the case, a generic term can be thought of as the common name for the class of goods. So naturally, that doesn't identify a particular source of those goods. What's a generic term cannot ever be registered as a trademark, and once a term becomes generic, it can never become non-generic, sort of a one-way trip. That's because it would deprive competitors of the ability to actually say the name of what they're selling, right? So here there was no dispute that pretzel is generic. There's no dispute that crisps is generic. The question was whether the combined pretzel crisps was also generic. So the court started out by looking at how the parties and others in the public, for example, use the name pretzel crisps. Was it, did they use it generically? Did they use it as a source identifier or trademark? So there were a few examples of the plaintiff itself using the term generically in emails, referring to its own product as pretzel crisps. The court found that a few kind of stray generic uses by the company were not really fatal. You don't have to be perfect when you're referring to your brand name. The plaintiff had introduced evidence of instances where they sent a cease and desist letter to competitors, and the competitors agreed, all right, well, we'll just stop using pretzel crisps. But the court concluded that these third parties may have just been looking to avoid a fight. They're being pragmatic in the face of an aggressive competitor. So they weren't necessarily acknowledging any trademark rights by agreeing to stop using pretzel crisps. Finally, the court looked at several references in the media to the purported pretzel crisps mark. But they kind of concluded that they really all flowed from the plaintiff's own press releases. So those instances really only showed how the company itself used the term. It didn't show how consumers viewed it. So overall, the court found that even though the pretzel crisp product was very successful, no question, it was well known among consumers, all of that evidence was still not enough to entitle this plaintiff to claim exclusive rights in the term pretzel crisps. So it affirmed that lower court finding. Next case is The Ohio State University versus Redbubble. This case looked at trademark infringement liability for companies like Redbubble that facilitate this sort of print-on-demand goods that you see, in this case, apparel. Redbubble markets clothing on their website, for example, and when someone places an order, they will notify the designer that they've made a sale. They'll arrange with third-party manufacturers to manufacture those goods, and they ship the products in this Redbubble packaging that you can see here. They've got garment tags, as you can see. They refer to the product as Redbubble garments, and they will process the returns and everything. Now, companies like Amazon that simply offer a marketplace for goods that already exist, some of which may infringe, they're typically excused in cases of trademark infringement liability because they're largely hands-off. The question here was whether a company like Redbubble, who, as we saw, is more hands-on marketing these things, can be held liable. So the Ohio State University found some goods on Redbubble that it felt infringed its mark, and they sued Redbubble for trademark infringement. There was no question here that the goods were infringing. The question was whether Redbubble was liable. So I put up the Lanham Act here, the relevant provision. The Lanham Act prohibits the use and commerce of any reproduction, et cetera, where such use would likely cause consumer confusion. Now, the district court concluded Redbubble was a transactional intermediary. They were not a user of the mark, so they were excused from liability. On appeal, OSU argued that they focused on this other bold provision that I've got here, use, in connection with, and they argued that in connection with kind of gave a lot of wiggle room there, where use should be interpreted pretty broadly enough to sweep in Redbubble. Redbubble, of course, argued more narrowly that only the people who are actually printing the goods, the manufacturers, or the designers who are selling the goods are the direct infringers. So the Sixth Circuit here on appeal interpreted the word use more broadly. To them, the key distinction was the degree to which the accused infringer here, Redbubble, holds itself out as the seller of the goods, or identifies the goods as its own. And here, as I mentioned, Redbubble really was doing that. So being more hands-on than Amazon and eBay, they were not able to avoid liability in this case. So the court instructed the district court to use that broader interpretation of use and, sort of continue the proceeding to see if Redbubble infringed. So the takeaway here is that if you're a passive reseller of goods, like an Amazon or an eBay, you may be able to avoid liability. But if the goods are marketed and sold under your own brand, you may well be in the hook. So the next case here is Beasley versus Hologic. As you may know, the TTAB determines the likelihood of confusion in opposition or cancellation proceedings at the USPTO. The question is whether that determination has a preclusive effect in later district court proceedings. So this is a long-running dispute between these musicians, David Beasley and William Howard. I don't know who's who in that photo. I was going to try to figure it out, but then one time. They're arguing over the name the Ebonies. Beasley had formed the group in the late 1960s in Philadelphia. Howard joined the group in the 90s. They eventually went their separate ways. Each claimed rights in the name. So Howard had, the latecomer, had federally registered the name the Ebonies in 2012. So Beasley petitioned to cancel that registration on the grounds of fraud in 2013. Something amiss in the paperwork or whatever you submitted, I'm not sure. But Beasley's petition was dismissed because he didn't put in enough evidence of fraud, apparently. So in 2017, he brought another cancellation proceeding for fraud. He also claimed priority, senior rights in the Ebonies mark. So the board again dismissed his petition. They said that both the fraud claim and the priority claim were barred by claim preclusion, also known as res judicata, since the fraud claim had already been decided back in 2013, and the priority claim could have been brought in 2013. It was based on the same fact pattern, but it wasn't. So Beasley didn't appeal, the USPTO's determination. He instead filed a federal lawsuit in 2019, again, making claims of fraud and priority in the mark. And now he is also seeking monetary damages, which are not available at the TTAB. So the district court affirmed the USPTO finding. It said that the board had already decided those issues and that claim preclusion held. So Beasley then appealed to the Third Circuit, which held that TTAB cases do not preclude the district court claims, even though the cases were based on the same fact pattern, because the TTAB has pretty narrow jurisdictional limits to decide trademark registration issues. So the proceedings there don't bar infringement proceedings in federal court, which deal with the use of trademarks as opposed to registration of the TTAB. The Third Circuit noted claim preclusion prevents parties from raising issues that could have been raised and decided in the prior action, even if they weren't. But it doesn't apply where a party is seeking a certain remedy that was unavailable in the earlier proceeding. So for both of those reasons, the TTAB proceeding didn't look at whether use of the mark, they were only considering registration. They didn't look at whether use of the mark would harm Beasley. And because Beasley was now seeking monetary damages that were not previously available, claim preclusion did not apply. So the Third Circuit joined the Ninth Circuit and the Second Circuit, which have both held the same. So the court reversed the dismissal and sent it back to the district court to be tried. So the takeaway here is that TTAB proceedings do not preclude federal court infringement cases. Next up is Select Comfort Court versus Baxter. This is a case that deals with initial interest confusion in the trademark context. That's confusion that creates initial customer interest or consumer interest, even though no actual sale results from the confusion. This is a case involving mattresses. Select Comfort owns a number of registered marks. You've probably heard of Sleep Number, what's your sleep number, things like that. So Select Comfort here had accused the defendant of infringing those marks on its website and elsewhere. The defendant was basically buying AdWords, using those marks, doing online advertising. It had a few similar domain names based on Sleep Number and things like that. But in the end of the day, the ads would always funnel consumers towards the defendant's website, at which point, a lot of times the confusion would be cleared up. It was clear you were not buying from Select Comfort anymore. So some consumers probably then walked away to go buy from Select Comfort. Some figured they were already there anyway and, just completed their purchase from the defendant. And that's kind of a classic initial interest confusion situation. It's almost like a bait and switch kind of scheme where consumers already there and just decides to complete their purchase. So at summary judgment, the district court rejected as a matter of law the idea of initial interest confusion. They instructed the jury that in any situation, you have to show that the consumer was confused at the time of the purchase. So the district court there was relying on this 2010 Sensient decision from the 8th Circuit, where the appeals court had refused to apply initial interest confusion because in that case, the typical consumers were found to be sophisticated. This was like, highly technical lab equipment or something like that, I forget. But the district court here said, well, mattresses are expensive, so people do their homework. So in this case, they're also sophisticated. So just like in that other case where the consumers were sophisticated, initial interest confusion is not a valid theory to prove infringement. So Select Comfort appealed. And on appeal, the 8th Circuit held that there really is nothing in the Lanham Act requiring that the person can only be confused at the time of purchase. Nothing bars an initial interest confusion theory. The court acknowledged it was bound by its own 2010 Sensient decision, but they noted again that was limited to situations where consumers were confused, and they found that wasn't really a clear case here. Shopping on the internet can be confusing. Sometimes it's unclear who you're even buying from. So it wasn't clear that the consumers here were sophisticated. So that meant the sentient decision really didn't even apply. Initial interest theory, initial interest confusion can be a valid theory of infringement. And so they reversed the summary judgment finding and remanded the case for further proceedings. So takeaway here is where, at least in the Eighth Circuit, where it's not a clear case of sophisticated consumers, where that's a question that the jury needs to decide, initial interest confusion is a valid theory. I think this is the last trademark case, and I've got a few slides after that, but Socialtech versus Apple. This is a case where the Ninth Circuit looked at whether using a trademark just for purposes of getting a trademark, getting a registration to then assert later in a lawsuit was a bona fide use of the mark. This is one where Socialtech had filed an intent to use application for the mark Memoji in 2016 in connection with a mobile app. And it got through the Patent and Trademark Office, it got a notice of allowance, but they hadn't proven use of the mark yet, so they did not get a registration at that time. In the following years, they didn't really do too much. They kind of made a marketing plan. They created some investor materials. They put up a website. That's kind of a little clip of it there from the right. They maybe talked with a code developer, but nobody ever developed any code. Again, they didn't really do too much until 2018. In early June, Apple announced the launch of their own Memoji feature in their new operating system. And now things started happening. Once Apple made its announcement, Socialtech started moving frantically. It put out this really buggy software that didn't even really work. A few weeks later, it was downloaded a few thousand times. Filed a statement of use at that time and got a registration. This quote is from their co-founder, who was inadvisedly writing these emails to people, his developers and others, trying to hustle things along to get something out there in the marketplace to be able to prove use, to get a registration, to sue Apple for infringement. So he was saying things like, this is life-changing, time to get paid, gentlemen. This is the best one. Get your Lamborghini picked out. Socialtech sued, and they got their registration. They sued. Apple moved for summary judgment, and it asserted that Socialtech was not making a bona fide use of the mark when it filed its statement of use. They really had, in other words, their intent was just to put out something in order to bring this lawsuit. And so, because it was not a bona fide use of the mark, the registration was invalid. And that's relevant because to register a mark, you have to be making a bona fide use of the mark in the ordinary course of trade, not just to reserve rights in the mark. So the court granted summary judgment for Apple. Socialtech appealed. And so the Ninth Circuit looked at Socialtech's activities before the Apple announcement. Nothing they did was public facing. Again, this is before Apple had announced it. They didn't really do anything. So that wasn't a use in commerce. After the announcement, all they did was rush to put out a buggy application in order to get paid by Apple and buy orange Lamborghinis, I guess. I don't know that anyone actually picked one this color, but anyway, so the court made clear that rush releasing a low quality product is not always going to be fatal. People do it, but there was just no evidence here at all that Socialtech had developed its application for genuine reasons that were the types of reasons that justify trademark protection. Even though there were a decent number of downloads, 5,000, that was still considered a token use merely to reserve their rights in order to sue Apple. So the Ninth Circuit affirmed the district court's finding that the registration was invalid. And the takeaway here is that even if you make some use, that would be sufficient under other circumstances. 5,000 downloads should theoretically be enough under other circumstances. The court's going to look at whether you have a legitimate commercial reason. And just in case anyone thinks I was making fun of orange cars, this is my car. It's hard to tell from the picture, but it's not a Lamborghini. All right, so we'll move on to just some brief trademark procedural changes. Nicole went through some of the others in other spaces. It was a pretty slow year for changes in the US with regard to trademark procedure changes. The major thing was this Trademark Modernization Act of 2020. That's a typo at the top there. It actually mostly took effect last month, with the exception of one provision. But the part that did take effect, two new ex parte cancellation proceedings for dealing with registrations that are invalid due to non-use. These are intended to streamline knocking out marks that are not in use, or versus an expungement proceeding. You can bring this if you believe the mark was never actually used in commerce. You have to request that within 3 to 10 years after registration. Though until the end of next year, 2023, that 10-year upper limit doesn't apply. You can challenge any registration over 3 years old in recognition of the fact that this just came out. Second is a reexamination proceeding. You can bring this if the mark was not in use as of the filing date for a use-based application, or as of the statement of use filing date or the deadline for filing one for an intent to use application. That just has to be all brought within 5 years after registration. Now, a big advantage of these proceedings is that anyone can bring them. The real party in interest does not need to be identified in most cases. So, for example, your attorney could file it and you can remain anonymous. What generally happens if this proceeding is instituted is an examiner will, look at the request. It will issue an office action requiring evidence of use from the registrant, and then that owner has 3 months to respond. The examiner will then look at the evidence, make a determination, and cancel the registration in whole and in part as appropriate. And that determination can be appealed to the TTAB. And finally, on the examination side of things, right now you have 6 months to respond to an office action. This new provision is going to cut that back to 3 months, except you can request, of course, for a fee, a 3-month extension to bring you back up to those 6 months. The PTO intended for this to roll out last month as well, but their systems couldn't handle it, so they're pushing it back a year. So that won't take effect until December of this year. And now I'm just going to touch quickly on one copyright decision that came down to close my portion of this presentation. We'll talk about the latest from Google versus Oracle. We discussed this case last year as well. You could do a whole presentation about the history of this case alone. I just wanted to touch on this, what happened this year with the Supreme Court. So this case deals with 2 questions about software and copyrights. Whether software application interfaces can be copyrighted, and we'll talk about what those are in a second. And if they can be, can an otherwise infringing use of them qualify as a fair use? So this case goes back to 2005 when Google was trying to get into the smartphone business with the Android, but they couldn't get a license from Oracle to use its Java application programming interfaces, or APIs. So an API is basically an interface that allows computer programs to talk to each other, accessing software libraries, databases, and such. You can see those kind of on the right of this little diagram here. They're the key to interoperability between computer systems. So the idea that one party could copyright the interface, that API kind of connector in the middle there, would have huge ramifications. So Google couldn't get a license. Its talks with Oracle broke down. So it developed its own underlying libraries, the heart of the code itself, but it used the Java declaring code, which is the names of the tasks that that underlying code performs, as well as the way they're organized in classes and packages. And it did that for 37 of the Oracle packages. And so predictably, they got sued by Oracle. So Google admitted the copying of the declaring code, but it argued that they were not copyrightable, that there wasn't enough creativity to them. They weren't creative work. But even if they were, it argued that it was making a fair use of the APIs. So this case made its way to the Federal Circuit a few times. Again, this is another case that's kind of gone up and down for years. The Federal Circuit most recently found, and we had talked about this in last year's presentation, that the API was copyrightable and that Google was not making a fair use. So Google lost on both counts there. So the case made its way to the Supreme Court this year, and the decision issued in April. Justice Breyer wrote the decision for a 6-2 majority. The court assumed for purposes of the decision that the API was copyrightable, but it didn't matter because they held that Google was making a fair use. And so it came to that decision by walking through the classic 4 fair use factors. They kind of took them out of order of the typical way you look at them, but at any rate, they looked at the nature of the copyrighted work. Because this is an interface, really the important part about it is the hierarchy in the organization, things that are not really copyrightable. And so the portion that they copied then is sort of inherently bound to this non-copyrightable idea. So that makes it unlikely that the use is going to undermine the spirit of the copyright laws, which is a concern that they're looking at. So because it's sort of far away from that concern, this factor weighs in favor of Google's fair use. Second, they looked at the purpose and the character of the use. In this case, was it transformative? Did it add something new? And the court found that it did. Google was porting the Oracle API from computers, desktops or laptops or whatever, over to smartphones. That's a creative thing to do in the court's view, and that's consistent with the purposes underlying the Copyright Act, which are to incentivize creativity. So that also weighs in favor of the fair use. They looked at the amount copied. Here, Google had copied something like 0.4% of the total lines of code, really only what it needed to make the software work. So that also weighed in favor of fair use. And finally, the fourth factor, they looked at the effect the copying had on the market for the value of the copyrighted goods, Oracle's software. In this case, it was kind of apples and oranges. Google's Android device was not going to be competing with a laptop or a desktop running Java SE. They work on different machines. So the court felt that, in that case, stifling the creativity of Google's use would do nothing really but harm the public. So this factor also weighed in favor of fair use. So the court found that Google's use was a fair use. So with that, I will turn it back to Amanda, and we will take any questions at the end.
Thank you, Nate, for those trademark and copyright decision updates. If you need to contact Nate, you can scan the QR code on the screen or find his contact information on our website. And if you have any questions for Nate, please drop them in the chat. You can send them to me. We'll try to get to them at the end of the presentations. Our next presenter is Eric Carnaval, who will be talking to us about developments in patent law in the federal courts and the PTAB.
Hello, everybody, and thank you, Amanda. Good afternoon, and welcome to the final portion of today's programming dealing with developments in patent law in the Supreme Court and Federal Circuit. Now, we're going to be touching on both the significant patent cases decided by the Supreme Court in 21, as well as a few selected issues from the Federal Circuit that seem to be showing real movements in the law. But because we have a lot to talk about today, I figure we'll just get right into it. So let's start with the Supreme Court. This has been what I would call a normally active year for the Supreme Court, having 2 significant cases before it. Although it was once rare for patent cases to make it to this top court since from the beginning of the Patent Act through about 2010. After 2010, you see a lot more interest in patent law from the Supreme Court. And the court has typically taken between 1 and 3 patent cases every year. Arthrex is one of the most closely watched patent cases of the year because of its potential impact on the structure of the PTAB and possibly the entire statutory scheme of the American Invents Act. Now, Minerva is a decision that could have significant effect on some industries because of the way it increased restrictions on the doctrine of assigner estoppel, the doctrine that says an assigner cannot challenge the validity of a patent that they sold. So let's begin by looking at U.S. versus Arthrex. Now, what I've put up on the screen here is an excerpt from the U.S. Constitution, Article 2, Section 2, Clause 2, otherwise known as the Appointments Clause. Now, the Appointments Clause is a personal favorite of mine because despite how much it says, it is delightfully unclear. The clause deals with the appointments of ambassadors, consuls, Supreme Court justices, quote unquote, other public ministers, as well as officers of the United States and inferior officers. So what are officers of the United States? Well, it doesn't really say. What are inferior officers? Also doesn't really say. What's the difference between the two? Doesn't really say. Is every federal employee an officer? Well, we don't quite know. Now, there's about a century of law that deals with trying to parse this one section of the Constitution and understand exactly what an officer of the United States is. So rather than go through all of that from Humphrey's executor through today, let's just take a high-level look and look at what we know about officers, inferior officers, and federal employees. Officers are probably the most easily understood. These are people that are appointed by the president and confirmed by the Senate. They occupy a continuing position established by law, and they exercise significant authority pursuant to law. These are generally cabinet-level officials or other department heads. Anybody appointed by the president and confirmed by the Senate, you would recognize as an officer. Now, subordinate to them are these inferior officers. They also occupy continuing position. They also have or exercise significant authority pursuant to U.S. law. There's only really two major differences. The first is how they're appointed, which the Constitution expressly prescribes, appointed by the president alone, heads of departments, or the courts. And the other thing that differentiates them from an officer is that they're directed or supervised at some level by somebody who is appointed and confirmed by an officer. Now, one thing you might notice from this arrangement is that if you go back to the wording of the Appointments Clause, everything that's shown here either comes directly out of the text or is very, very logically closely related to the text of the Constitution. I cannot stress enough, despite 100 years of jurisprudence, how little interest the Supreme Court has in explaining the Appointments Clause. This is really all we know for sure. Now, distinguished from officers or inferior officers, we have federal employees. These are people who are hired through the normal federal hiring process. Their duties can be temporary and occasional, or they only perform ministerial acts, and their position is not specifically established by law. Most of the some million plus federal employees are not officers of the United States, just federal employees. So that brings us to the inciting act of this story, Lucia versus the Securities and Exchange Commission. This case came before the Supreme Court in 2018 concerning administrative law judges at the Securities and Exchange Commission. These ALJs occupied a position established by law to hear cases and issue decisions. While the decisions were not final, they are subject to review by the commission. If the commission declines review, then the decision becomes final. So they do exercise important authority pursuant to U.S. law over the cases that they have jurisdiction over. The ALJs in this case were appointed by SEC staff, not the commission itself. That created a constitutional problem because, as we know, anybody who occupies a position established by law and exercising significant authority under the law is either an officer or an inferior officer. And that means they must be at least appointed by the president, the courts, or the heads of the departments. These ALJs were not. They were inferior officers in the guise of ordinary employees. But because this issue was relatively easy to correct, it was. Before the case was even decided by the Supreme Court, the SEC moved to ratify the appointment of ALJs by reappointing them through the head of the department, through the commission. This was effectively enough to ratify their position as inferior officers, and the SEC more or less continued as it was. That brings us to the patent connection to this long story of agency law. This is Arthrex versus Smith and Nephew. This is a patent dispute involving knotless graft fixation devices. What are effectively dollies that you can drill into a person's bone in order to anchor tissue grafts. And it's really gross. I love the technology. Great aspect to this story. Arthrex, the patent owner, lost its IPR, but its lawyers had apparently read Lucia. And it made the same argument in Lucia, that the Patent Trial and Appeal Board's administrative patent judges were unconstitutionally appointed, and the Federal Circuit agreed. So let's take a closer look at why. APJs have the authority to review and revoke patent rights, so they exercise significant authority pursuant to U.S. law, and their final written decisions in IPR are unreviewable by any executive officer, even the director of the PTO. An adverse decision can be appealed to the Federal Circuit, but no executive branch official can overrule them. And finally, APJs can only be removed on the grounds of misconduct. They can't be removed at the pleasure of the agency department head or even the president themselves. So unlike Lucia, which involved inferior officers acting under the guise of being mere employees, we have a situation where APJs have authority on par with being a principal officer, like a cabinet level official. But beyond that, even cabinet level officials serve at the pleasure of the president. They can be removed without cause. APJs cannot. And that was at the heart of the Federal Circuit's fix. They found that these APJs were improperly appointed principal officers. So they severed the limitation against removal without cause, causing the APJs to have a more direct connection to their senior official, the department head, the patent office itself. But nobody was really happy with this solution. After all, just because the APJs can be removed without cause doesn't necessarily mean that they have any meaningful direction or supervision on a day-to-day level. The director of the PTO probably isn't going to be making many of these removals, and probably not because of their specific actions during an IPR, for example. So this issue caught the attention of the Supreme Court. Now, having looked at Lucia, we might wonder, what's the deal about all of this, right? In that case, the agency just ratified the appointment of its judges by reappointing them the right way and moved on. The issue was done. But the PTAB is different. Judicial independence and strict limitations on review and appeal are built into the underlying structure of the PTAB, and it affects the entire statutory scheme of the American Invents Act. And the American Invents Act has made some enemies on the Supreme Court. Justice Gorsuch, in particular, has repeatedly voiced his displeasure with the AIA and the trend, he says, of handing over judicial powers involving the disposition of individual rights to executive agency officials. He's faulted the majority of the court for having acquiesced to the AIA's provisions, allowing agency officials to withdraw already issued patents subject to very little judicial review. This is a point that Justice Gorsuch has repeatedly made. I'm quoting here from a 2020 decision, Thrive versus Click to Call. But I could have picked another quote from the 2018 Oil States decision, 2017 SAS Technologies. This is a major trend. And every year that we've done these presentations, I have pointed to one of Justice Gorsuch's dissents and said, you know what? This issue probably isn't over. So we have a constitutional challenge to the AIA, where an aspect of the AIA is clearly unconstitutional in a way that's central to the objections of at least one justice who has repeatedly expressed a desire to toss the entire law. These are the stakes for the case going to the Supreme Court. But in the end, the court decided not to blow up the PTAB, and that's probably a good thing. However, they did alter the Federal Circuit remedy. Supreme Court read into the law the right of the director of the PTO to review the final decisions of the APJs and issue a decision herself on behalf of the board. Now, I will note, however, that Justice Gorsuch concurred in part to say that he also agreed APJs were unconstitutionally appointed, but he would have tossed the entire statutory scheme, that is, the AIA, and sent the issue back to Congress. Given that the AIA was originally previewed as a potential act of 2000, before it was eventually enacted around 2012, gives you a sense of what would have happened to this had Justice Gorsuch's opinion carried the day. But Justice Gorsuch was not joined in his opinion by any other justice. So while in years past I might have said, this isn't over, in this case, we have the clearest challenge to the AIA in many years that was right up Justice Gorsuch's alley, and he didn't find other votes. I'm starting to think might be over. So in conclusion, what has happened? The PTAB has survived with small modifications. There's the right to review an APJ decision by the director that is sufficient to make APJs inferior officers. It's unclear how often the director will intervene and how meaningful this intervention will be, but there is this new right. This is something that Nicole touched on earlier today. But there is one major upside for parties appearing before the PTAB. So previously, the only way to challenge an APJ decision was to appeal to the Federal Circuit. Now, in cases that were decided a few years ago, we found out that not all parties who can appear before the PTAB have Article 3 standing to appeal. So it's possible, particularly where you IPR a patent without having a direct fear of litigation against you. Nonprofit entities, some consortiums that are trying to clear the way for standard essential patents, things like that, have tried to IPR patents that were in their way, but they don't necessarily have Article 3 standing because they're not at risk of being sued in court by the patent owner. So for these parties, they effectively had no meaningful way to review an adverse decision. Once the PTAB made their decision, it was over. They had no right to appeal. Now they at least have recourse to the director. So this might be an avenue of new litigation, review, growth by having these sorts of issues heard by the director. And not all of them are going to be a dead end. Maybe. We'll see. So that brings us to the second Supreme Court case we're going to talk about today, Minerva versus Hologic. So this case deals with the concept of assigner estoppel. This is an equitable doctrine in patent law, so it's not codified in any statute, but it's a very, very old doctrine. And this is one that has been traditionally of great benefit to assignees because it has been applied relatively inflexibly over the years. Virtually any assignment or assigner estoppel case begins with an excerpt from the case that I've shown on the screen here, Westinghouse versus Formica, a 1924 opinion which held an assigner of a patent right is estopped to attack the utility, novelty, or validity of a patented invention which he has assigned or granted as to anyone claiming a right under his assignment to grant. As to the rest of the world, the patent may have no efficacy and create no right of monopoly, but the assigner cannot be heard to question the validity or question the right of his assignee to exclude him from its use. And this has traditionally been a hard and fast rule. If you assign, you cannot attack the novelty, utility, or validity of the invention you've assigned. Period. End of story. Now, in certain cases, that hard and fast rule can feel unfair. Now, let's look at what happened in this case to see why. So in the late 1990s, an inventor named Kasaba Trakai created an invention that detects perforations in a person's uterus through the use of carbon dioxide gas. He assigned all of his patent rights to his company, Novoset. Now, although his first patents related to this invention were issued in the late 90s and early 2000s, the company kept this patent family alive with continuing applications. In 2004, Novoset was purchased by Cytec Corp. In 2007, Cytec Corp was purchased by Hologic. Now, at that point, Trakai leaves Hologic and founds his own company, Minerva Surgical, working in the same general field. Nothing happens between competitors for several years. But in 2013, Hologic files a new continuing application on Trakai's original late 1990s disclosure, seeking to capture the work that he was doing at Minerva. The patent issues in 2015, and Hologic sues Minerva shortly thereafter. This is the basis for the claim of unfairness. Trakai had left Hologic 5 years before this patent was even filed. But because it claims priority back to his original work, which he assigned to the company, Trakai and Minerva were stopped from even challenging the validity of the claims that Trakai had no role in writing. Now, the Federal Circuit recognized repeatedly in its opinion that this felt somewhat unfair, but under its precedent, this was largely irrelevant, stating that it's irrelevant at the time of assignment that the inventor's patent applications were still pending, and that the assignee may have later amended the claims in the application process, which is a very common occurrence in patent prosecution, with or without the inventor's assistance. They did say that Minerva had some recourse. Since a valid patent claim can't cover the prior art could be introduced to narrow the scope of the claim, but not invalidate it. But that really didn't answer Minerva's primary contention here, which is that Trakai didn't believe he invented what Hologic later claimed based off of his specification. So that's how this issue came up to the Supreme Court. At stake was, first and foremost, whether the doctrine of assigner estoppel should exist at all. The Supreme Court has expressed great hostility to non-statutory equitable doctrines. It wants all of these things spelled out in the law as much as possible. But some equitable doctrines are old enough and established enough that the court really can't afford to toss out the baby with the bathwater. So at least on this issue, the courts recognize that the value of the equitable estoppel rule. When an assigner later raises an invalidity defense to a patent they assigned, they're implicitly disavowing their own implied warranties in the original assignment. And as the court explained, that course of conduct by the assigner strikes us, as it has struck many for many years, as unfair dealing, enough to outweigh any loss to the public from leaving an invalidity defense to someone else other than the assigner. But Still, the rigid application of this doctrine is a problem for the court. It ruled that because this is an equitable doctrine, assigner estoppel should apply only when the underlying principle of fair dealing comes into play. But when the assigners made neither explicit nor implicit representations in conflict with an invalidity defense, then there's no claim of unfairness in its assertion. Now, uncharacteristically for the Supreme Court, it gave us a number of clear examples where these fundamental principles of fairness are not invoked. Suppose, for example, an employee assigns their rights with future inventions to an employer, and the employer gets to decide what, if any, inventions to patent. Well, in that scenario, the assignment contains no representation that a patent is valid. How could it? The invention itself has not come into being. Or suppose later legal developments render the assigner's warranty invalid. If the law changes and makes what was valid suddenly invalid, the inventor may claim that the patent is invalid in light of the change in the law without conflicting with his earlier representation. And most notably for this case, what if the claims of the patent change after it's been assigned, especially a change that broadens its scope? Well, assuming that the new claims are materially broader than the old claims, the assigner didn't warrant to the new claims validity. Now, that last one is a big exception. It takes a great deal of power away from companies that may want to limit the ability of former employees to compete against them by drafting new claims on an old patent disclosure to cover the former employee's new work with a competitor. Companies can still try that, but there are much stronger disincentives now against going too far afield because the inventor can now dispute the validity of those patents. They couldn't before. This is a huge shift in the law. Now, that brings us to the Federal Circuit, and there's at least one more issue dealing with these IP assignments that I want to cover there. After that, I want to discuss some policy issues, and including some speculation regarding the PTAB's discretion to deny IPR petitions for administrative efficiency, and the Federal Circuit taking a harder look at Section 112 issues, which is one of the big statutory issues that I'm going to look at today. So let's continue on with issues dealing with assignments. And I only have one case from the Federal Circuit here, but it dovetails really nicely with the Supreme Court's Minerva opinion. This is Bio-Rad versus ITC. Now, beginning in 2010, a group of inventors working for QuantaLife executed broad patent assignments covering all of the present and future IP that they developed at the new company. In 2011, Bio-Rad acquired QuantaLife, and the inventors made new assignments to Bio-Rad in addition to the previous assignments. Then in 2012, events start to pick up steam. The inventors leave Bio-Rad and form 10x Genomics. In 2013, the inventors conceive of a new invention in the same field as their original work for Bio-Rad, and, at least for the purposes of this case, this date of conception in January 2013 is undisputed. Beginning in 2017, the 10x patents, the inventor's patents, issue, and in 2019, 10x filed an ITC complaint against Bio-Rad. Among Bio-Rad's defenses, they argued that they were joint inventors of the 10x patents because the 10x patents rely on ideas and concepts that were first developed by the inventors at Bio-Rad. So to be clear here, Bio-Rad failed to dispute the date of conception of the 10x patents. So they're not arguing that the invention was conceived or reduced to practice at Bio-Rad. Their argument is instead that the assignments the inventors executed were broader than just the legal inventions and covered any and all, quote, ideas, processes, and any all ideas, processes, recipes, trademarks, service marks, works, inventions, discoveries, marketing and business ideas, and improvements or enhancements of any of the foregoing. So their idea is the assignment was so much broader than inventions themselves that the fact that they came up with the underlying ideas at Bio-Rad gives Bio-Rad rights in the invention later conceived of at another company. But no, says the Federal Circuit. Now, on one level, the court found that any assignment that could be construed to force an employee to give rights to post-employment inventions to a former employer would be offensive under California contract law. There is movement in a lot of contract law in a lot of states in favor of the portability of employees and against restrictions that would inhibit competition by former employees. Now, on another level, the court stressed that the touchstone of an invention assignment is that the invention must be conceived of to be designed. A person's work, just because it might one day turn out to contribute significantly to a later patentable invention and make the person a co-inventor, is not itself protectable intellectual property before the patentable invention is made. Even if the assignment of the underlying ideas and concepts had been effective, fundamental ideas and concepts do not make one a joint inventor. Inventorship is about conception or participation in the conception of the invention. But ideas and concepts don't make you an inventor. So let's take a big look at the conclusions that we have from 2021 developments in assignor and assignee law. So the touchstone of assigner estoppel is whether the assigner has given express or implied warranties about the validity of the claims. If not, assigner estoppel will not apply. If so, assigner estoppel will apply. Changes in the claims after assignment can still affect those warranties, though, as well as changes in the law. And employers are now more restricted against forcing the assignment of underlying ideas or concepts or having their assignments carry with an employee after their employment in material ways. So I would expect to see a lot more litigation in this space in the years going forward. We're seeing some more cases at the Federal Circuit touching on these issues. This is not the only Federal Circuit case on assignments that was heard in this year, and I fully expect this to continue. So keep an eye out in the next couple of years for more information about this. Now, let's turn to the PTAB and discretionary denial. That requires a little bit more explanation. Prior to 2018, the Patent Office had interpreted the American Invents Act as giving the office the right to institute inter partes review on only a portion of the challenges raised in a petition. This frustrated a lot of people. First, because a partial institution still required the payment of full IPR fees, which cost tens of thousands of dollars, whether the board institutes on one claim or 20. And second, partial institution is found nowhere in the statute itself. This was an administrative decision by the Patent Office to reduce the strain of adjudicating a large number of IPRs. But in 2018, the Supreme Court looked at this question and agreed that there's no statutory basis for partial institution. It is an up or down decision. The director may institute or may not, period. Now, that could be a problem for the PTAB because petitions for inter partes review tend to be huge, and many have a combination of good and bad arguments. In a world where even a single meritorious challenge to just a single claim could force the PTAB to consider a petition with dozens of flimsy challenges to dozens of claims, the PTAB just didn't want to do that. But thankfully for them, they had an out. The director has discretion to deny a petition regardless of the merits. But of course, discretion is not absolute. So the board requires some kind of system to exercise that discretion to deny petitions. And it formalized this in a 2020 IPR entitled Apple versus Fintif. These are the Fintif factors, which I've shown on the screen here. Now, rather than read them, I'm just going to summarize a couple aspects of them. Factor number one provides an out to courts that want to hold on to patent cases. If you move through a case quickly, you can keep it. If you move through the case slowly and or don't want to grant a stay pending IPR, you can stay the case and give the case over to the IPR, but it puts the control in the hands of the district court. Factors number 2, 3, and 5 penalize people who sit on their rights. And factor number 4 penalizes people who tend to raise the same issues before the district court. Finally, and oddly, least importantly, because this deals with the merits, factor number 6 penalizes low quality petitions. So you have an overall scheme here that rewards quick filers, punishes slow courts, and gives a lot of power back to the district courts to adjudicate patent matters. So rather than look at cases, let's take a look at some statistics to see how this may or may not have affected filings and institutions. So we don't have any hard answers yet, but we do see a sizable shift in how people are bringing these patent challenges. In 2020, this is data that is straight from the USPTO's statistics on inter partes review. We saw a noticeable drop-off in new IPR petitions being filed. And significantly, the bulk of this drop-off has been borne by granted petitions, falling from 859 in 2019 to 648 in 2020. Meanwhile, denials stayed relatively constant, going from 510 to 507 in the same time. The board instituted fewer IPRs and people filed fewer IPRs. Now, where are people going if not to IPR practice? Well, let's contrast this with ex parte reexamination. Ever since IPR began, new ex parte reexamination filings have dropped precipitously, going from a high of about 780 in 2012 all the way to a low in 2019 of about 163. That is until 2020, when ex parte filings jumped from 163 to 198. We don't have statistics for fiscal year 2021, but I wouldn't be surprised to see this trend continue. And that is a significant shift. Parties are moving away from IPR and towards ex parte reexam, where this scheme of discretionary denial doesn't exist. Is that entirely due to FinTiv? Well, probably not. Yeah, I don't know if you've heard, there was a pandemic during this time that has affected the federal courts in a lot of ways. It's affected a lot of agencies in a lot of ways, and that has played on these incentives as well. But it feels more material that for the first time since IPR was created, we have a jump in ex parte reexamination filings. Now, this is also playing into a big issue that is going on in the district courts right now, because the federal circuit has been engaged in a battle over venue with a handful of district courts that have shown a strong desire to keep patent cases on their dockets. Most notably, you see these battles being played out in mandamus petitions to transfer cases out of the Western District of Texas. In late 2020, for example, I'm just excerpting a handful of these mandamus cases that were decided by the federal circuit, by the way. In late 2020, federal circuit found that the district court abused its discretion by sitting on a motion to transfer until after claim construction and then denying transfer based on the advanced stage of the case. You can't do that. You have to decide a motion to transfer quickly and hold other issues until that part of the case is resolved. In several cases throughout 2021, the federal circuit has found that the Western District abused its discretion by refusing to transfer venue where the plaintiff clearly attempted to manipulate venue in the Western District of Texas, and Texas had no meaningful local interest in the case. These mandamus petitions are ongoing, so I could have picked any of about half a dozen of these cases to show you that, this is a fight dealing with who controls jurisdiction over these cases. So FinTiv is playing into this battle over jurisdiction here. The harder that a court can keep possession of a case, the more likely it will be to keep possession of the case. And they have a strong incentive to fast track these cases. So districts that are rocket docket districts, I would expect them to be rocket docket districts plus in the years going forward, in part because of things like FinTiv. Now, I did have another section dealing with written description issues, but this and a lot of our cases, if you want more information, we have some great scholarship on the Lando Anastasi website. I know I talked a lot about assignments and patent assignments and employment agreements. Just late last year, we had a great article by Tom McNulty and Peter Lando, along with Tyler Grutadaria. I've written extensively on the Arthrex decision. Much of that information is posted on the Lando Anastasi website as well. So if you have more questions, want more information, please take a look at our scholarship and then let us know what you think. And with that, I'm going to hand everything back over to Amanda, and we can get to the question and answer period.
Thank you, Eric. The first question is actually for you, Eric. It says, do you have any practice recommendations in view of Minerva and the other assignment decisions?
The practice recommendation I would have for this is when you're trying to draft claims to cover an invention by a former employee, there's going to be a lot more skepticism on the written description. I think in years past, it was fairly easy if your only real competition in the industry was, say, your former employer, you could go really far afield on trying to capture your former employee's claims in a new patent filing, and they really had very little recourse to challenge you on that. Now they do. So the best practice I could say is take a really hard look at new written description guidance and be more rigorous with how you use the written description to write your claims, what you include in the written description, because there's a lot of changes, a lot of development in the law, a lot more scrutiny on that in general by the patent office and the courts. So if you want to play games to capture a former employee, that's going to be a lot harder. Just play the game fair.
Thank you, Eric. And we have a question for Nicole. It's, do you think the first office action interview pilot program will be revived?
Interesting. A lot of practitioners really appreciated having, and applicants liked that pilot program as an opportunity to, again, kind of start the dialogue earlier and, have a lot more interaction, get an initial read on the examiner's position and what they thought was the closest prior art. My understanding is that the program, was sunset, not because, that the patent office felt like it wasn't working logistically or, in terms of procedure, but instead they honestly weren't getting the requests from applicants. Not sure if perhaps it was sort of a lack of education or something like that, but I think, there's probably an appetite. I think the patent office and the examining court thought that it was helpful, but surprisingly, they weren't getting the participation requests. I'm not aware of, nothing comes to mind instantly where there's been precedent for, something kind of being brought back that I can think of off the top of my head, but it wouldn't surprise me. I think it was a step in a good direction.
Thank you. We have a question for Nate. It says, is there an ex parte proceeding available for cancellation of an intent to use application, trademark application that is, that has not yet been used in commerce?
Well, you wouldn't have a cancellation proceeding in that case because it wouldn't be a registration if it's still based on intent to use and not been used yet in commerce. But I think to answer the question as best I can, there is no corresponding opposition proceeding in place. I think the purpose of these new ones is this. It's really this frustration that you encounter, or feel as a practitioner, where a mark is a cited mark, a registered mark is cited against an application of your client, and it's very clear just from like trying to find this registrant's website that this is not a thing. It's like a laughable specimen that was photoshopped, or it's clear they've gone out of business or whatever, but you still have to get into this whole full, adversarial proceeding to prove that. So it's all that to say, I think the concern that's, really been being dealt with here is registered marks rather than ones where they just haven't shown use yet. So there is no corresponding opposition proceeding, but it's not a bad idea.
Thank you, Nate. We have another question for Eric. It says, what is the status of pre-Arthrex PTAB decisions? Can they be challenged?
So there has been some guidance put out by the Patent Office and by the Federal Circuit to raise these Arthrex decisions, and there is case law on that subject, which we can get into at another time. Because this is a recent issue, the court is more or less setting aside the normal barrier that you have to raise these issues below before the appellate court will consider them. The appellate court will now consider these issues raised for the first time on appeal. And because this is a change in the law, you are able to raise them if you have a adverse decision by the PTAB. However, you have to make that affirmative election at the soonest opportunity. A lot of parties may not want to do so because they have, or the law doesn't give you a whole lot of new substantive rights with regard to these an adverse decision. It's not changing the standard of review per se. It's just taking a second look. We don't even really know what standard of review the director is going to apply to it. So there's a lot of open-ended questions about what we're going to be doing for this in the long run. But yes, there is a way for you to raise this either with the federal circuit if you're on appeal, or if you haven't gotten there yet, to request rehearing by the director at the patent office.
Thank you, Eric. We have just one more question here. This one is for Nicole. It says, what is the status of the UK within the UPC? That's the Unified Patent Court.
Right. So because the UK is not part of the EPC, it's not going to be part of the Unitary Patent Court. Not only does a member it has to be a member EU country, and on top of that, participating in the Unitary Patent and Unified Patent Courts. So the UK is not part of the EU. So it's out on that basis. There are other countries, Spain, I think, is notable, perhaps Poland, which, even though they're EU members, they haven't yet signed up and ratified the relevant agreements for the unitary patent. So I think it can change over time. A couple of those holdouts, my understanding that it's going to be dictated as of the date of grant. So applicants will be able to either go ahead with the national validation procedures or a hybrid, and also get the unitary patent. The unitary patent being defined by those countries participating at the time of grant.
Great. Thank you, Nicole. And thank you, everyone, for participating. As a reminder, the recording will be made available on our website at a later date. And if you need to contact any of the presenters, you have any additional questions, you can reach out to them by scanning the QR code or writing to them at their emails, which are on the screen. Thank you.